everyone. Welcome to Crime in Court. This is episode 102 of the Canton cover up series, Commonwealth versus Karen Reed, and it is titled Hank Breenan Calling the Kettle Black. So, if you are looking at your screen, to your left, we have Robert Alessi, who had oral arguments on Friday up against Hank, now always will be and forever known as Breenan, um, in front of Judge Cannoni regarding the cell phone, the forensic cell phone expert for the defense. So Hank, in his infinite wisdom, decided that he was going to waste the court and Karen Reed's time and money and taxpayers' money and Karen Reed's money to have all these hearings regarding a Daubert hearing for experts who have already testified and have already been qualified as experts in other courts. So it's kind of odd that he would choose this route, but maybe he has nothing else to grasp at. Perhaps there's nothing else uh, that he can do because the facts aren't on his side. So anyhow, we're not going to watch the hearing. I was just going to briefly explain that. So Robert Alessi had oral arguments. He was phenomenal, by the way. If you haven't seen it, I highly recommend you watch it. He does a great job arguing. Hank Brennan, on the other hand, he didn't do such a great job arguing his points, and he seems to have forgotten that the whole point of a Daubert hearing is to determine the expertise of your witness. But his arguments were all about the opinion of the witness being wrong. So it was very clear that Judge Cannoni really has only one choice, and that is to deny the Commonwealth's motion to exclude Richard Green's testimony and or have a Daubert hearing. So this is actually the note from Judge Cannoni after the hearing on Friday took place. So this was their original filing. They did it back in January, and it is the Commonwealth's motion to exclude defense witness Richard Green's debunked opinions, but they put opinions in quotes. So this is Cannoni's note here that she just wrote on January 31st, 2005, after hearing and review of the written submissions, I have determined that I can decide this motion without any further hearing. B. Cannoni. So what that means is she said at the end of the hearing that she would decide this, look through everything and then give a written order back. Well, she said she would call a hearing if she felt that a hearing was needed, but she did say originally, I think this does sound more like a difference of opinion. So it does seem that this is going to be denied. Why she couldn't just say this motion is denied, I don't know. Because she's probably going to come back with some snark comments and, come back with some, well, have every, it's well within my discretion, to allow experts, but I'll allow it, even though he's testified in state and federal courts like 2 dozen times. So, anyways, but I would be really surprised if she does um, deny the defense the opportunity to put Richard Green on. I don't think she's going to exclude him. So I think he's coming in. I think that's a very telling sign that it's coming in. So I don't know. She gives herself away kind of with her attitude and stuff. So I can see this being like she just wants to get her last word in and say, well, I could have gotten rid of him. But anyways, so we have a lot of motions to get through. Actually, not that many, but there were a lot of things that were filed. So let's kind of just go an overview of the docket. We have Commonwealth's opposition to defendant Karen Reed's motion to recover expert-related expenses from the Commonwealth. We're going to go over that. Commonwealth's motion for clarification of privilege filtration protocols pertaining to the defendant's phone. We'll go through that. And then there was two affidavits from Special Prosecutor Hank Brennan. I don't know why, but we will go through those as well. Um, oh, there was a protective order regarding communications produced in the Commonwealth's discovery. That's under seal, so we won't see that. Commonwealth defendant joint motion for a reconstruction and certification of record. Not sure what that is. Um, it's a joint motion, so not sure. And then the certification of record is, I think, doesn't the Commonwealth have to certify that they have provided all of the discovery over to the defense? So then in that regard, they get a certification of record. I think that's what that means. I'm not a lawyer, so whatever. All right, so the Commonwealth's motion for protective order regarding communications produced in the Commonwealth's Notice of Discovery 57 endorsed, so ordered. And like I said, I believe that is under seal. But we do have some other filings here. We have most of them that were on those lists. So here is the Commonwealth's motion for clarification of privileged filtration protocols pertaining to the defendant's cell phone. Now comes the Commonwealth and moves for clarification relative to the Commonwealth's lawful access to the defendant's cell phone. The Commonwealth has legal authority pursuant to a February 2nd, 2022 search warrant to examine the contents, including the forensic data within the defendant's cell phone. Because of privileged communications contained within the defendant's cell phone by order of this court and agreement of the defendant, the Digital Evidence Laboratory of the Attorney General's Office was appointed as the forensic examiner to review the defendant's cell phone pursuant to the search warrant and excise any privileged communications. Okay. Uh, at the conclusion of the Attorney General's Office search and confirmation by the agreement of the defendant, the Digital Evidence Laboratory of the Attorney General's Office was appointed as the forensic examiner to review the defendant's cell phone pursuant to the search warrant and excise any privileged communications. At the conclusion of the Attorney General's Office search and confirmation by the defense that all privileged communications have been withheld from the Commonwealth, the Attorney General's Office produced a redacted Cellbrite extraction report, including text messages and Google searches from the defendant's phone to the Commonwealth. Pursuant to the search warrant, the Commonwealth intends to obtain the raw data relative to navigation information and Google searches from the defendant's phone for comprehensive forensic review. If you recall, even in the first trial, Lolly kept trying to say that Karen Reed went back to 34 Fairview Road that morning, and I think that's what they're trying to get at with these Google searches and navigation information, like where was she at what times, um, and did she go back to the scene to check to see if he was gone or not, if she had done it, um, and knew he was there. But as we know, that's not the case. Anyway, so the Commonwealth has a good faith and reasonable belief that the privileged filtration protocols for attorney-client communications would not apply to navigation or Internet Google search histories, despite the Commonwealth's belief that this information is not under the purview of the communications protocol. Out of an abundance of caution, the Commonwealth requested that a forensic examiner from the Attorney's Office produce the raw data of navigation and Google search files that are within the time frame and scope set by the search warrant. Although the Commonwealth contends that they have independent, lawful access to these files, the Commonwealth sought for the independent forensic examiner previously appointed by the court to review the files to ensure that no attorney client communications nor any other privileged communications were inadvertently produced to the Commonwealth. The Commonwealth informed the defense of its intentions, and the defense is objecting to the Commonwealth's request for the raw data within the scope of the February 2nd search warrant. Given the pending April 1st, 2025 trial date, the Commonwealth is seeking to avoid any unnecessary delay in reviewing evidence and, in consequence, seeks the court's clarification relative to the privilege filtration protocol. So, whatever all that means, there are um, obviously privileged communication. So they're just asking for clarification now of what uh, protocols are being done, just to make sure that they're not um, kind of overstepping there on their, I guess they're being cautious, which is fine. All right, so this is the Commonwealth's opposition to the defendant Karen Reed's motion to recover expert-related expenses from the Commonwealth. If you recall, we went through a motion where Karen Reed's defense team is requesting that she get reimbursed as like a 12,000 something uh, dollar fee because the expert that she had hired flew out to, they all pre-planned this and they scheduled it. He flew out to their office and was told that, oh, we don't know why we would even have that information because it's not here. 30 days, everything just magically erases in Norfolk County, don't you know? So he did some more digging and learned that there might have been some manipulation and things nefarious going on to perhaps hide the Sally Port video. That's what he was going there for, and to get the raw data for the Sally Port video. Flew all the way there, did all the work, to get there, and I don't know what you're talking about. Even though that woman is the woman that made the appointment. Colleen Crawford is her name. She made the appointment and then suddenly had amnesia as to what the appointment was about. So this is Hank's opposition to that reimbursement. Says now the Commonwealth in the above captioned matter and opposes the defendant's motion to recover expert expenses from the Commonwealth. The defendant's suggestion that the Commonwealth misled or induced the defendant to incur costs to have an out-of-state expert travel to the Canton PD is a distortion of the facts and has no legal merit. How does it have no legal merit? You guys made the arrangements. You said, yeah, come on out. We'll show you around. We'll give you all the stuff you need. And then she does have her guy go out there, and yeah, it doesn't make sense to me. But no legal merit. Okay. The Commonwealth requests the court deny this motion without a hearing. The Commonwealth has provided the defendant with numerous videos from the Canton Police Department throughout the entirety of this case. At no time has the defense ever made a formal preservation request. They shouldn't have to. This is potentially exculpatory evidence. They shouldn't have to. This is evidence in her own case. Shouldn't have to make a preservation request, but okay. In November of 2024, the defense made an informal discovery. Hold on, I'll wait till my dog goes by. In November 2024, the defense made an informal discovery request relative to additional Canton Police Department videos. Special Assistant District Attorney Brennan, there he spelled it correctly, responded on November 25th, 2024, informing the defense that he would inquire of the Canton PD and or keeper of the records to attempt to identify any potential. Okay, so hold on, let me reread that. Special Assistant Attorney Brennan responded on the 25th, informing the defense that he would inquire of the Canton PD and or the keeper of records to attempt to identify any potential chain of custody of video footage provided and would request any documentation that may exist relative to the chain of custody of surveillance video. During the week of December 1st, 2024, ADA Brennan spoke by phone with Attorney Jackson and his counsel. Attorney Jackson asked if the Commonwealth would consider allowing a defense expert to access the Canton Police Department's camera system. So no motion or order has been allowed or even filed relative to this request. ADA Brennan agreed to accommodate the defense's informal request. Why did they need a motion? They don't need a motion. They can call you and say, hey, do you agree to this? Yes. Okay, great. We don't have to go through the judge. Okay, cool. Bye. They don't need a formal motion to do this, but cool. Okay. Brennan thinks that motions come to him uh from the defense, apparently. All right, so during the phone call, Attorney Jackson expressed concern that the video footage would no longer be stored, and ADA Brennan acknowledged and shared Attorney Jackson's concern given the passage of time. Attorney Jackson requested the Commonwealth refrain from accessing the system prior to the defense expert's examination. ADA Brennan met with Canton Police Chief Rafferty and received permission for the defense to search. Why would they need to meet? Why do you need permission from Chief Rafferty? And received permission for the defense to search for video from the Canton Police Department's DVR system relative to the storage of the defendant's vehicle. Pursuant to Attorney Jackson's request, ADA Brennan directed Chief Rafferty to advise her staff not to disturb the NVR video system prior to the defendant expert's examination. Are we sure about that? Because Hank Brennan had to go meet with Chief Rafferty. Why was he meeting there? Like, you got to meet with her in person? You can't just call her up and be like, hey, they want to come over. Cool. Okay. When can we set that up? ADA Brennan also invited the defense to tour the entire Canton police station and note all camera locations. ADA Brennan informed the defense that the Commonwealth would have a forensic examiner from the Norfolk County District Attorney's Office and Massachusetts State Police trooper present. The Commonwealth videotaped the procedure to memorialize the event. The defense expert visited the Canton Police Department on December 12th, 2024. It was learned at that time, nearly 3 years after the incident, that the footage of the NVR was overwritten and the system no longer maintained an original surveillance footage. I call BS. They would have saved it somewhere in order to get it to the defense. So what'd they do with it? Moreover, in efforts to identify video footage and chain of custody, ADA Brennan visited the Canton Police Department, viewed camera locations, and had a discussion with retired Sergeant DiGiapietro, sure, DiGiapietro. Sergeant DiGiapietro served as the officer who originally obtained and produced video from the Canton PD. Sergeant DiGiapietro informed ADA Brennan that he routinely would make a copy of footage obtained from the NVR and preserve footage on the department's work server slash hard drive, which is separate from the NVR file system. Prior to its motion for costs, ADA Brennan informed defense counsel during a conference call that retired Sergeant D.G.M. Petro would routinely save video copied from the NVR onto the department's hard drive. ADA Brennan offered to produce a copy of the stored footage from the Canton Police Department's hard drive or, alternatively, allow the defense direct access to the hard drive. The defense deferred this offer and has requested further information about the hard drive storage that is forthcoming. The Commonwealth never suggested that nearly 3 years later, on December 12, 2024, that video footage from January 29, 2022 would still be stored on the NVR system. These guys are so disingenuous. Nor did the Commonwealth in any way hinder the defense's desire to have a defense expert view the Canton Police Department NVR. Oh, we didn't get in their way of viewing it. It just wasn't on our system. Sorry, Your Honor. The footage simply no longer exists on the NVR system of the time that has elapsed. Therefore, the defendant's motion should be denied without the necessity of a hearing. I think not, sir. I think you either need to just pay it outright or you need to have a hearing because I wouldn't stand for that. All right, this is why we call him Breenan. After the horrible arguing that he did, his oral arguments on Friday's motion hearing, he basically discredited Richard Green because he didn't know how to spell gray key when gray key is likely the affidavit itself was likely written by the attorneys. And the attorneys probably spelled gray incorrectly. Gray, there's two different spellings of gray. You can spell it with an E or you can spell it with an A. So whatever the product is, I don't know they spelled it the opposite way the first time, and then they corrected themselves in their second affidavit. And he's saying because there was a corrected, amended affidavit from Richard Green, which was just like spelling and stuff like that. But so now Hank's argument at the hearing was, well, he can't even spell Reiki right, like how can he even be a credible witness? Well, Hank Brennan can't even spell his name right. How can he be a credible human? Is what I would say. So, affidavit of Special Prosecutor Hank Breenan in support of Commonwealth's response to the defendant Karen Reed's motion to recover expert-related expenses from the Commonwealth. My name is Hank Breenan. I have been appointed Special Prosecutor assigned as lead counsel for the Karen Reed case. I began my appointment in mid-September 2024. I learned that the Commonwealth sought and obtained a search warrant for the defendant's phone on February 2nd, 2022. I learned that the phone information was provided. Sorry, I lost my place because I scrolled too fast. We'll use these. Where was I? I learned that the phone information was provided to the Attorney General's office pursuant to a privileged filtration protocol to ensure that no privileged information was provided or viewed by the Commonwealth. I learned that the Attorney General's office provided reports relative to communications, navigation, information, and Google searches. I recently learned that the Attorney General's office did not provide the Commonwealth with the related raw forensic data from the defendant's phone. And now they're asking for the raw file, and the defense is saying they don't need the raw file. After consulting with forensic experts, I believe a comprehensive forensic review of raw data within the scope of the search warrant will provide more information than the reports. I learned that the defendant's been in possession of the entirety of data, including the raw data from her cell phone, since 2022. Although I do not believe my requests involve communications and thus not subject to the communications protocol, I requested that the Attorney General's office engage in a filtration protocol for files I requested, including navigation information and Google information. This request was an effort to scrupulously protect the defendant's privileges. So they're trying, he's like, we're really trying hard to keep her private, privileged conversations private. I informed the defense of my efforts and the defense advised of its objection. I do not believe the defense has any standing to object. Well, that's great for you, but the defense can object if they want to object. However, after receiving the defense objection, I contacted the Attorney General's office and asked them to limit the production of to files identified by the Commonwealth's forensic examiner as navigation files. Based on my conversations with the forensic expert and understanding of what a privileged attorney client communication consists of, I do not expect any communications to be stored in the navigation files. Upon speaking to the Attorney General's office, it is my understanding that they would like to follow the filtration protocol previously set by this court and by agreement of the defendant. The Commonwealth is seeking clarification so that it can efficiently obtain all data it is entitled to pursuant to the search warrant and review of the data prior to trial. So that was one of his affidavits. Now we have a second version of his affidavit. So let's read this one. I began my appointment in mid September 2024. During my initial review of discovery and documents in the custody of the Commonwealth, I learned of a letter written by Canton Police Department Chief Rafferty, dated August 21st, 2024, accompanied by a zip drive and contained video footage of multiple areas of the Canton Police Department. Accordingly, I promptly provided these materials to the defense. Okay, so these are for two different motions. This one, the first one was for the expert payment. That's why we have two affidavits from him. One was for the reimbursement of the expert payment, and then this one is the Sally Port, sorry. So accordingly, I promptly provided these materials to the defense soon after becoming aware of the information. I had phone calls with Attorney Jackson during the first week of December. 2024. Attorney Jackson requested an opportunity to have a defense expert access the Canton Police Department NVR for examination. I agreed to seek permission to allow the defense to access the NVR for examination. I contacted Police Chief Rafferty and obtained permission for Attorney Jackson's request. I informed Attorney Jackson that I would have an MSP officer attend along with the Norfolk County District Attorney's Office forensic examiner present. So that's the Crawford lady, Colleen Crawford. I also informed Attorney Jackson, that we would videotape the procedure. Attorney Jackson expressed concern that the materials may no longer exist on the NVR. Given the time that had passed since the event, I agreed with him and told him that I had no knowledge whether the materials still existed or were overwritten given the passage of time. So either he is a big fat lying liar in an affidavit to a judge, or I don't know. I never represented that any video from the storage of the defendant's vehicle would exist on the NVR system nearly 3 years after the event. Attorney Jackson requested that I refrain from having anyone access the NVR. So he told us not to touch it, so I didn't look at it. But I couldn't confirm that it was there because I couldn't look at it. So do you see? Do you see the level of mental gymnastics they all have to go through for their excuses? I agreed and informed Chief Rafferty of his request that no person access the NVR prior to the defense examination. I personally met with Chief Rafferty and requested that no person access the NVR prior to the defense expert examinations. We were just doing what we were told, Your Honor. God, I like him even less than I liked Lolly, and I did not like Lolly at all. So, not going so well. Um, for him anyways. But the very last filing that I have is a scheduling order. I just kind of wanted to go over this. This is Beverly is always like, we got to get moving. We got to move forward. I want us to make sure that we hit our date. So, according to as of today, February 1st, it is 59 days to trial. So, that's not a lot of time. So, they're trying to stick with an April 1st start date, which that would be when jury voir dire begins. So anyhow, so the leading up until trial starts, let's see what they have on the schedule. So February 5th is the Commonwealth will file their certificate of compliance, meaning that they turn over all of their discovery to the defense. Following day, February 6th, there's a motion hearing. Then so that is not, what is that? That is this Thursday. There is a motion hearing. Then the 11th, we have a filing of a motion to dismiss and all evidentiary motions. That's the deadline for that, and that's not in court. Commonwealth, the 14th, Commonwealth to file opposition to their motion to dismiss and parties to file pretrial conference report. That's out of court. So we know that the defense team is going to be filing the motion to dismiss. So they let Judge Canoni know, and she was like, "Okay, hurry up and file that." So basically, so I could dismiss it is what her or deny it was pretty much her response to that. So hurry up and get it to me so I can crush your hopes and dreams of allowing it. So the 18th of February, we have a hearing on the motion to dismiss. February 21st, there is a filing of all evidentiary motions, and that's going to be out of court. March 4th and 5th, evidentiary motion hearing, and the 7th, we have a final pretrial hearing with motions in limine. March 18th and 19th, hearing on all motions in limine and final trial conference. And then April Fool's Day, trial begins. Signed, the lovely Beverly Canoni. We have not heard back from the SJC yet, so I don't know if we are going to go forward with an April 1st date, but Judge Bev is dead set on an April 1st date because she keeps pushing for that, which fine if you guys are ready in time and if you have an SJC ruling, but you can't really try her for something that hasn't been resolved yet with the SJC. So either we get something from the SJC soonish or we get to push back the date, I think. Personally, I don't know. And we don't know when we're going to hear back from the SJC. They could do it anytime. So I don't know. What do you guys think? Do you think we'll have an April 1st trial starting on April 1st? Canoni really wants it. Do you think we will go to trial? Do you think something is going to be just so explosive in the dismissal, motion to dismiss that there's no way we can go forward? Let me know your thoughts below in the comments. And please hit the like button on your way out. Thank you so much for watching. Take care, guys. I'll see you in the next one. Bye now.